Donald presides over this case. Sit back and enjoy.
Thank you, Your Honor. We're present in case State of Ohio v. Cedric L. Kennedy, case number 24 CR 729. The defendant is present today in court represented by Attorney Bill Watson. We were previously in court on January 8th, 2025, where the defendant entered a plea of guilty to count 1, having weapons while under disability, a felony of the 3rd degree. Count 2, having weapons under disability, also a felony of the 3rd degree, as well as count 9, receiving stolen property, a felony of the 4th degree with a 18-month gun specification under revised code 2941.141. This matter was then referred for a pre-sentence report and a victim impact statement, and we're scheduled for sentencing here today. Thank you.
Okay, Mr. Watson.
Thank you, Your Honor. May it please the court. Mr. Kennedy is a troubled man with a troubled, long past with the criminal justice system. And the vast majority of his past, and in this case, all stems from his mental health issues. Mr. Kennedy is a schizophrenic, Your Honor. When I first met him in the jail for this case, Mr. Kennedy turned to me and said, "Look, I just need some help. I've got problems. I keep hearing voices in my head." We talked for a while. I filed a competency motion. He was found not competent initially. He was sent to North Coast, where he began a treatment regimen, mainly through medication. That seems to have worked. They found him competent. They sent him back. I've had numerous conversations with Mr. Kennedy. He's expressed to me that the medication calms him, makes him think more rationally.
Who's that? Who is that?
Taylor.
That was good.
Oh, okay. All right, go ahead.
Your Honor, I know none of that is an excuse for his behavior. I know that the court is going to have concerns. Well, you know, he's going to be out on the street and stop taking his meds and do stupid stuff again. And although I certainly can't offer any promises or guarantees to the court that that won't happen, I can tell you, again, I've spoken to Mr. Kennedy, he does not want to continue down this path in life. Now, he knows today that he's going to prison. He knows there's mandatory time on this case. The question is, how much time is this court going to impose upon Mr. Kennedy? I'm respectfully asking the court to consider a minimum sentence in this case. I do believe Mr. Kennedy is sincere when he's expressed to me, and the court's going to hear from him directly in just a minute, that he wants to continue taking his medication. He wants to be more of a quote-unquote normal person. He does not want to be off his meds and have the thoughts that go through his head. So, Your Honor, again, I know there's no excuse for what he did here. He has taken responsibility for his actions, and I'm respectfully asking the court to consider a minimum sentence. Thank you, Your Honor.
Thank you. Mr. Kennedy, what do you want to tell me?
How you doing, Your Honor? To piggyback with my attorney said, Your Honor, it's been a tough journey for me. I just kind of fell downhill, you know, without my medication, you know, pretty much just trying to find my way. And I do know, you know, with the right resources and the proper help, I could turn things around and see things in a better light and live in a productive manner how society sees fit, and be more of a safe asset to my community as well as the communities that I come across. I do not want to live like this no longer. I am broken beyond I can say, Your Honor. I want to thank my attorney here for, you know, speaking up and giving me the help I needed. And I also want to thank you, Your Honor, for making it possible to send me to North Coast and give me the help that I needed. And I do believe if given a chance, you know, with the medication that's been given to me, and I could turn this around. I just want you to take in consideration that also I have a newborn child, you know, that I pretty much I'm a mess up, and you know I've been creating these patterns for some time now, you know, and like I said, I'm broken, and I can't do this no more. You know, I give up, and I just want to live right.
All right, thank you. Ms. Wood?
Thank you, Your Honor. On behalf of the state is recommending a higher prison sentence. This was a case where the police were called due to a disturbance with the victim, the owner of the firearm that is noted in count 9, as well as in the having weapons under disability, count 1. The police had to wrestle with the defendant to place him under arrest, and he was very uncooperative with them, where they located 2 different firearms on his person, one in the front of him and one in the back of him. These firearms, one of them belonged to the victim in this case, and he did not have permission to have either of them. He's under disability. He's pled to a prior firearm specification. The defendant's conduct in this case, and looking at his past criminal convictions, demonstrate that he's unable to comport himself within the law. He has juvenile offenses that began when he was under the age of 18 and then continued to commit criminal offenses into adulthood. He has several convictions for offenses of violence. He has been to prison before, and he was placed on post-release control in the past. And then the pre-sentence report notes that he was arrested in the state of Florida. I don't believe that the defendant would have permission to leave Florida, but it just shows that his conduct, even after serving prison, is not in compliance with the law. He's unable to follow the orders placed on him. The state is recommending a higher tier prison. We would also ask if the defendant would voluntarily agree to the forfeiture of the firearm specifications to the appropriate law enforcement agency, and we believe that he would be entitled to the 276 days of credit. That includes the time that was spent at North Coast. Thank you.
All right, I've reviewed the pre-sentence report. I've gone back and looked at the reports related to the competency. And I've considered all the provisions in 29, 29, 11, 12, and 13. On count 9, I'm going to sentence you to 18 months in prison. And then on the firearm specification, a mandatory 18 months in prison, which shall be served consecutive to, or prior to and consecutive to the underlying offense on count 9. On count 1, I'm going to sentence you to 12 months in prison. On count 2, 12 months in prison. Those 2 counts will run concurrent to each other, but consecutive to count 9. And I find that consecutive sentences are necessary to protect the public from future crime and for the appropriate punishment, and they are not disproportionate to the seriousness of your conduct and the danger you pose to the public. And as indicated in the pre-sentence report, the history of criminal conduct demonstrates that consecutive sentences are necessary to protect the public from future crime. Is this a optional 2 years, or is it on the POC?
I believe so, Your Honor. Yes.
All right.
Optional 2
When you
years.
get out, you might be on post-release control to the parole authority for up to 2 years with conditions. If you violate the conditions, the parole authority could return you to prison for up to 9 months for each violation, up to 1/2 of my sentence. If that violation is a new felony, then you could get an additional consecutive prison sentence for the violation, the maximum of which is the greater of 12 months of the time left under post-release control. Now, you've got a lot of problems that may very well stem from your psychiatric condition, and until you address that, you're gonna, as the pattern indicates, you're gonna keep coming back here. So you've got about 3 years and 3 months to do, and then you're gonna have to deal with that problem. Anything else, Ms. Wood?
No, Your Honor.
Mr. Watson?
Nothing further, Your Honor.
Okay, we're adjourned.
Oh.